And representing the permanent members of the Siting Board, Louis Alexander, alternative Basil Sagos of the Department of Environmental Conservation, Dr. Elizabeth Lewis Michael, alternative Dr. Howard Zucker, Department of Health, Vincent Ravsher, alternative Howard Zemsky, Empire State Development Corporation, who is participating via video conference from the Department of Public Services New York City office, John Williams, who is alternative Richard Kaufman, New York State Energy Research and Development Authority, and I'm John Rhodes of the Public Service Commission. Secretary Burgess, are there any changes to the agenda?
There are no changes to the agenda today.
With that, let us proceed to the agenda. Case 15F0327, request for interlocutory review filed by Kara and Anthony Dibna of the examiner's ruling on party status and intervenor funding in the application of Galoo Island Wind LLC for a certificate of environmental compatibility and public need pursuant to Article 10 to construct a wind energy project, presented by John Sipos, Acting General Counsel. Brian Assayas, Assistant Counsel, is available for questions. John, please begin.
Thank you. Good afternoon, Chair Rhodes, Siting Board members, and alternate designees. The matter before this Siting Board today concerns an interlocutory appeal by a party in the Galoo Island Article 10 proceeding from an earlier ruling by the examiners denying intervenor funding to that party. The focus of the proposed draft order before you today in my briefing will focus on the procedural question and the procedural posture of whether the Siting Board should consider the appeal at this time. And by way of background, in this case, the hearing examiners denied Kara and Anthony Dibna's request for intervenor funding to participate in this stage of the proceeding. Interlocutory review of a ruling will be available and may be sought, but only in extraordinary circumstances, and that is pursuant to 16 NYC-RR Section 4.7. Ultimately, the determination of whether extraordinary circumstances exists is fact-specific and is done on a case-by-case basis. Here, the Dibnas have been permitted to participate as a party, but have not been awarded intervenor funding to cover expenses that they may incur. The draft order before the Siting Board today finds that the interlocutory appeal does not demonstrate extraordinary circumstances as required by the aforementioned Section 4.7. Specifically, and contrary to the Dibna's assertion, there is ample opportunity for meaningful participation in the application process, even without intervenor funding. As noted, the Dibnas were granted party status, meaning that they can participate in the same manner as they have previously done. And for example, as noted, they retain access to the Public Information Coordinator's office, can engage in discovery, submit exhibits, and otherwise engage in the proceeding. Should the Dibnas ultimately believe that such measures and opportunities are inadequate, nothing precludes them from retaining counsel at their own cost to proceed in the proceeding and represent their interests. This concludes the summary of our presentation, and Brian and I are available should the board have any questions.
Thank you, John and Brian. I find this to be a straightforward matter based on the laws described and the facts as presented. So it's very clear and helpful to me. Thank you. Are there any comments or questions from my fellow board members? Shall I begin with you? Louis?
I have no questions.
I have no questions.
No questions.
Vince in New York?
No questions.
All right, Ms. Joan Treadwell Woods.
I do have some brief comments, and if you can see my pages, it looks like I've brought a term paper, but I assure you I haven't. It just has very large print so I can see it. So I'll be pretty brief. But since my appointment in 2016, I have attended sessions with the 3 administrative law judges regarding the application of Galoo Island wind. Today, this is my first involvement in a meeting of the New York State Board on Electric Generation Siting and the Environment. It is my pleasure to meet with you all. I do have concerns about the proposed order, and I'd like you to understand those concerns. These concerns are addressing the exclusionary approaches being used to limit the scope of those receiving intervenor funds. I would like to briefly describe these concerns so that you have a better understanding of my position. On page 6 of the proposed order, there's a sentence there that begins with, given the legislature's specific inclusion of a definition of local parties, and then it goes on for the rest of the sentence. I disagree with that statement, and I cannot support it. I find it hard to believe that the intents of the legislature or the authors of PSL Article 10 were to be so exclusionary. If their intents were indeed exclusionary, then shame on them and the consequential harm to Northern New York and to all of New York State. After much reading, I see no discrete, specific place in the statutes that prohibits intervenor funds from being distributed to all local parties. Although there are some definitions, and there are what I call connections of dots, which can lead to an interpretation of exclusion, I believe other interpretations are possible. I also contend that the Dibnah's situation, being what we in Northern New York call seasonal residents, could be termed an extraordinary circumstance. And let me further explain. Jefferson County, which also includes the town of Hounsfield, has a significant percentage of residents whom we call seasonal, and our local economies heavily depend on them. Many seasonals are preparing for their eventual retirement in Northern New York. These seasonal people represent a huge portion of the town and county tax bases, and they spend considerable monies in addition. Some start new businesses, and they support our local communities in many other ways with their volunteerism. These seasonal folks often are owners of undeveloped properties or properties needing improvement. We in Jefferson County welcome these seasonal residents, and we want them here. We want more to come here. We do not want to give them reasons to leave. We do not want to chase them away. Our towns, our county, and our local economies heavily depend on them. These seasonal residents are very much impacted by exclusionary practices to limit the scope of eligible applicants for intervenor funds. Without access to such funds, these people are at high risk of being able to defend their properties and property values, especially so in the Dibnah's situation. They were refused funds in August of 2016 during the pre-application phase, and now the recommendation is that they again be refused. This is really a travesty, especially when their property, which shares the island of Galoo with Galoo Island wind, is on the National Register of Historic Places. I'm going to conclude now. These are my views and my input into a process that appears to be exclusionary and far from being equitable. I'm very concerned that the objectives of having a whole process and a complete record for the siting board to review are not being met. And I thank you very much for listening to me.
Thank you very much for these thoughtful comments. John, Brian, are you in a position to respond?
Given the procedural posture that this appeal is in, given that it is an interlocutory appeal, further discussion about the hearing examiner's application as well as the underlying statute, I would suggest at this time would be not appropriate by council. As in this case, the DIBNAs did present an appeal. That appeal is measured against Section 4.7 and the extraordinary circumstances requirement, and the proposed draft order that is before your honors today addresses that procedural context. The typical American rule in jurisprudence is for there not to be interlocutory appeals, as that can lead to piecemeal litigation, and one consequence is that every order of a lower tribunal or a trial court can then be appealed as soon as it is made. The typical rule is for there to be an appeal at the end of the entire proceeding. And in this situation, in this circumstance, the draft order concludes that the DIBNAs did not satisfy the extraordinary circumstance standard.
Thank you very much. May I just ask a question? It's my understanding that multiple parties have in fact received intervenor funding in this case, and that they have put it to, I'll use a non-legal term, good use in terms of articulately and eloquently making their views known and developing, supporting support for those views. Is it the case, to your understanding, that intervenor funding has flowed in this case and has been used by at least some, and again I'll use a non-legal word, active intervenors?
That is correct, Chair.
Thank you. Are there any further comments or discussion that we need to have? Seeing none, I will proceed to call for a vote with the facts and interpretation of laws presented to us, and acknowledging that this is against the background of an active, a case with active intervenors. My vote will be in favor of the recommendation to deny the request for interlocutory review as filed by Anthony and Kara Dibna as described. I'll now proceed to ask my board colleagues. Mr. Alexander, how do you vote?
My vote is also in favor.
Dr. Lewis Michael?
My vote is also to approve the order.
Vince, Mr. Ravachere?
In favor as well.
Mr. Williams?
In favor.
Ms. Treadwell Woods?
Sorry, I was on mute. Not in favor.
There are 4 votes in favor. The matter is approved and the recommendation is adopted. Secretary Burgess, is there anything further to come before us today?
There's nothing further to come before you today.
Mr. Chairman, if I may
Please.
just note for clarification for the record, I know that the 2 DPS ALJs were referenced as being in attendance. I also wanted to note for the record that the DEC ALJ assigned to this matter is also in attendance today.
That's a fantastic clarification. Thank you. With that, before we adjourn, may I thank the board members, and especially thank Joan Treadwell Woods for her care to this matter. We are adjourned. Thank you.
We're not going to make America great again. It was never that great.